I'm Jeffrey Rosen, the president of the National Constitution Center, and I'm sitting here with Neal Katyal, former acting Solicitor General of the United States. We're here to talk about the Supreme Court, privacy, and technology. Now, there are certain cases where the justices have acted rather boldly and with surprising unanimity to try to translate the Fourth Amendment into a new technological age. The first of those was the Jones case involving GPS tracking. Tell us about that case, first of all. What were the facts?
So the facts in Jones were particularly hard for the federal government to justify. But basically, they had someone they suspected of being a drug dealer. And so they did what you often do in that circumstance, which is you seek a warrant so that you can search them and seize them and things like that. And in this case, they just wanted to follow this man Jones's Jeep around. So they sought a warrant. They applied for the warrant and got it in one jurisdiction, but it turns out Jones was in another. They also got it for a certain period of days, and they didn't actually attach any sort of GPS tracking device until after the warrant had expired. So basically, the government had goofed up at various points in the case early on. But nonetheless, it came to the U.S. Supreme Court, and the question was it okay for law enforcement officials to attach a GPS tracker device to this guy's Jeep without a warrant? Because the government obviously couldn't rely on their warrant. It was out of time and in the wrong jurisdiction. And the federal government said, look, we don't need a warrant. I mean, we tried to get one, but we didn't need one because Jones's Jeep is in plain view. Everyone could see it. He's just driving around the streets. And undoubtedly, every justice on the Supreme Court, the government said, would agree that we could pay a cop to go and follow Jones around for 24 hours a day. So what's the difference between having a cop do it or a digital cop do it in the form of this little GPS tracker device? Everything's done in the plain view. It's not as if Jones was driving on private roads and private property or something like that in which the GPS tracker was surveilling him. So the federal government thought, hey, we got a pretty good argument. Everyone agrees that we could do this in real space without technology, so why can't we do it in cyberspace?
Now, the Supreme Court unanimously rejected that argument, but they did so for different reasons. Tell us, first of all, what Justice Anthony Scalia, joined by 4 other justices, held.
So Justice Scalia said, I don't want to get into this whole question about cyber surveillance, because here really what's going on is you, the government, attached a physical device to someone's property, to Mr. Jones's Jeep. And by doing so, you invaded his property interest. You trespassed on them. And Justice Scalia went back and looked at the common law tradition of trespass and said it bears a lot of relation to the Fourth Amendment, and that basically what the government did was invade a property right of Mr. Jones. Now, the problem with that argument is that the government often invades property rights in all sorts of circumstances. I mean, for example, the government chalks tires all the time to figure out whether or not someone has overstayed their 2-hour meter limit. That is them physically touching someone else's property and would invade the same property right that Justice Scalia was asserting. And for that reason, I think the other opinions in the case ultimately will be more persuasive and long-lasting.
So tell us about those other opinions. Justice Samuel Alito, as you said, was unpersuaded by Justice Scalia's property-based analysis. Why was he unpersuaded, and what was his alternative?
Well, I think Justice Alito recognized that what really was going on is not some sort of property rights violation. What's really going on is the notion that this was mass surveillance and could be adopted on a grand scale. And this reached its culmination in another opinion by Justice Sotomayor, which made this point very explicitly. But at the end of the day, when someone says they're concerned about GPS tracker devices on someone's Jeep, I don't think they're concerned about the limited 2 seconds it took to attach that device onto the Jeep. Rather, they're concerned about the fact that this tracker is now broadcasting all sorts of information about them. Where they go. Did they go to a drugstore? Did they go to some anonymous lover's house? Who knows? There's so much information that the government could get access to through the use of these trackers, and that's what 5 justices on the court, well, several justices on the court were concerned with.
That's exactly right. As you say, Justice Alito said that because of the amount of information that month-long tracking could reveal, we do have an expectation of privacy in the whole of our movements.